Well, good afternoon, everyone. Welcome to the first session after lunch, usually the graveyard session, not for today, on Director Liability, the Case for Reform. My name is Sarah Barker. I'm a special counsel in the corporate group at Minter Ellison Lawyers, and with full disclosure with John on a panel, I also facilitate the Company Directors course for the Australian Institute of Company Directors. Now, this is definitely going to be an improvement on the panel prior to lunch because there are only 50% lawyers on the panel and amongst the chair today rather than 75%. Now, of course, the subject of personal liability or responsibility of directors is perennially a high-profile issue, but it's particularly high-profile at the moment around the issue of the safe harbour that corporate directors have in relation to business judgments they make, which is the business judgment rule defence to the duty of due care and diligence. Now, as disappointing as it is to me as a corporate lawyer, we are not going to debate the minutiae of the wording of Section 180, subsection 2 of the Corporations Act this afternoon. I know, it's so disappointing. What we do want to do, though, is look at that broader policy context that underlies the rationale behind the concept of having a safe harbour defence for directors exercising their business judgment. So looking at that from the perspective of the interests both of asset owners and of corporate directors. Now, of course, the rationale of the safe harbour really is a balance between two critical economic interests. The first, of course, allowing directors the flexibility and the discretion to make business judgments, to make sensible commercial judgments around risk without fear of liability, which of course is necessary to maximise financial performance. And this needs to be balanced though against that second economic interest, which is ensuring good corporate governance and to ensure that there's accountability from corporate boards back to their shareholders and other stakeholders. So in that context, we're going to be looking at the question, well, is the current form of safe harbour, the current business judgment rule, is reform to that warranted? And if so, why? Now, the three panellists we have to address that question today, I don't think we could get three better panellists in the room to be talking about that question. First of all, we do have the Chief Executive Officer of the Australian Institute of Company Directors, Mr. John Brogden. He is the former CEO of the Financial Services Council and also former CEO of health insurer Manchester Unity. So if you would join me in welcoming John. Second, we have Portfolio Manager and Director of Allan Gray, Simon Malwini. Simon's been at Allan Gray for 9 years, and prior to that he had various finance and equity roles at Alliance, Bernstein, Macquarie and Deloitte. So if you'd like to join me in welcoming Simon. Finally, we have Professor Ian Ramsey, and my head may explode with Mervyn King on one side and Ian Ramsey on the other in terms of the corporate governance knowledge that's coming at me on both sides. Ian is the Harold Ford Professor of Corporate Law at the Law School at the University of Melbourne, and he's the head of the Centre for Corporate Law and Securities Regulation there. He's practiced law at firms in New York, in Sydney, and he's been a member of advisory and review panels in both the public and private sector, more than you could poke a stick at, including the Takeovers panel, CAMAC and for ASIC, and is head of the Australian Government Inquiry on Auditor Independence. So if there's something about Australian corporate law that this man doesn't know, it's probably not worth knowing. If you'd join me in welcoming Ian. Now, I think accountability is going to be one of the key themes today. And as moderator, I am accountable for ensuring that the session runs to time. So I am delighted to have an excuse to use my gavel. It doesn't get brought out very often. So gentlemen, you'll get a bang with a 1 minute warning, and after that you may get it thrown at your heads. So So with that threat hanging over your head, John.
Thank you, Sarah. I want to particularly acknowledge Gerard Noonan, the president of AXI, and who I've known Gerard for many, many years, pre-superannuation. And the last time I couldn't make it to an event chaired by Gerard Noonan, he did the empty chair trick and put my name on it. So in the full knowledge of that, I decided I'd better come today. I do want to also congratulate you on dealing with the important and critical issues of mental health in the workplace. I'm very pleased as a sufferer of depression, but also as the chairman of Lifeline in Australia, that you've taken that on as such an important issue. I do note that you had the superb Helena Morrissey speak today, and I'm very pleased that AXI has embraced the 30% target. You may have noticed that the OECD followed suit, although went further to suggest that all boards, not just ASX-listed boards, should aspire to a 30% target. I'm very pleased to have this opportunity to talk here today. The OECD strongly believes the current director liability framework in Australia is broken and isn't conducive to enabling boards and therefore companies to perform at their best. Speaking to the investment community, there are common themes about what we would like to see from directors, boards and the regulatory system more broadly. These include a desire for directors to provide more information on the future directions of the company or forward-looking statements, an expectation that the companies they invest in are represented by capable, high-performing directors, boards and management, a desire for boards to set a healthy risk appetite for their organisation that drives value creation, and certainty that incompetent or fraudulent behaviour by directors is dealt with strongly. The last thing we want is for the reputation of directors to be damaged by the actions of those who don't do their job properly. Equally, the overwhelming effort of boards must be to focus on the performance of the organisation rather than simply compliance obligations. Only this will drive long-term value for shareholders. I'm also confident that boards want to provide investors with more information to help with their investment decisions where appropriate and where it doesn't include commercially sensitive information. But it's extremely difficult to provide this information in the current regulatory environment, an environment where directors are held personally liable for a decision they make or information they provide which, with the benefit of hindsight, turns out to be wrong through no fault of their own. Fundamentally, our system of regulation needs to acknowledge that in the pursuit of opportunity, not all risks will or can be mitigated. Some businesses fail. Some businesses make mistakes. And these failures and mistakes will occur, and honest people will sometimes make those wrong decisions in hindsight. There's no doubt that directors should be held liable in certain situations, particularly for any criminal or reckless behaviour. But I wanted to provide some examples of where I think the laws have gone too far. The former federal government passed a law which holds directors personally liable for unpaid superannuation guarantee entitlements for their companies. Now, some of us may argue that that liability is appropriate. However, what's extraordinary about that law is that it makes directors liable for the unpaid superannuation even if this occurred before they became a director of that company. Let me give you another example with respect to insolvency. The practical reality of insolvency laws in Australia, and this is played out in companies around the nation every day, is that they encourage directors to opt for voluntary administration days or sometimes even weeks before it is necessary. The primary driver for this is a deep concern for their own personal liability. The law discourages attempts to rescue businesses which might otherwise be saved. This isn't consistent with a culture that encourages innovation, entrepreneurism and value creation. Worse still, these decisions, and we rarely hear of these, are regularly made by startup companies. This has two very negative consequences. Firstly, it deprives the economy of real opportunities for wealth creation and economic growth. And two, it discourages the animal spirits in us all that encourages commitment and investment in future startups. And remember that almost all big companies were small at some stage. So whilst it's a fine balancing act, I firmly believe the pendulum has swung too far, and as a result we have a risk-averse decision-making culture in Australia. This view is supported by surveys we conduct with our membership, including our most recent Director Sentiment Index, which will be released tomorrow. It finds that over 60% of directors believe the risk of personal liability causes them to take an overly cautious approach to decision making. It could be argued this statistic represents a biased director perspective, but perceptions can't be ignored because they are critical in driving behaviour. The current liability framework is impacting the number of directors willing to take on board positions. Now, before many of you say it, yes, you're right, there are certainly no shortage of people willing to become company directors. But the real question is, are we capturing the best and brightest in Australia to join boards? If you're an expert in a particular field, would you look to join a board, or, considering the risks of personal liability, take the option to consult to boards and companies without personal liability? More and more people are opting out of non-executive director careers. The AICD firmly believes that directors must be encouraged and supported to make appropriate business judgments in the interests of shareholders without the constraint of concern about personal liability. This issue has been defined as a director issue, and we must share, if not shoulder the blame for that perception. So today I want to argue that it's a shareholder issue. If the growth of companies, their ability to take calculated and informed business risks, is inhibited by legal constraints on those who govern the company, then shareholders lose. In 2014, the AICD proposed the honest and reasonable director defence. We believe this will go some way to addressing the problems with Australia's current director liability frameworks. I want to take some time to explain why we believe a change such as this is essential. First and foremost, our proposed defence extends to a range of provisions in the Corps Act and the ASIC Act. It is a broad legal defence which could be used by directors accused of breaching their legal responsibilities. It would apply where directors had acted honestly, for a proper purpose, and with a degree of care and diligence they rationally believed to be reasonable in all circumstances. It is not widely understood that the existing business judgment rule in Australian law only applies to a very small section of the Corporations Act. It only applies to the duty of care and diligence in the Corps Act and does not extend or work for business judgments that directors make in other areas, such as those concerning continuous disclosure, insolvency and forward-looking statements. As yet, no director has been able to successfully rely on the business judgment rule as a defence. This is largely because the business judgment rule is not available as a defence to the majority of the provisions of the Corporation Act. This is also because courts have taken a very narrow view as to what constitutes a business judgment. Common director activities such as monitoring affairs of the company or staying up to date on a company's financial position have been found not to constitute business judgment. It's also important to remember that if the defence we propose was to be adopted, directors would need to prove each element of the defence. Depending on the evidence presented, a court may or may not decide that a director has made out the defence based on the facts. It's no different to any other case involving a citizen who finds themselves in a courtroom facing allegations. A defendant may choose to argue their case using a particular defence, but that doesn't mean a judge or judges will find in their favour. Our goal is to encourage an environment where directors who act with integrity and commitment, honestly and reasonably, are free to pursue and harness new opportunities, drive performance and create jobs and wealth without being hamstrung by the onerous regulation and without being overly focused on personal liability concerns. The aim of the honest and reasonable director defence proposal is to stimulate a conversation among the governance community about how we can create that environment. So while we can disagree on the details of our proposal, I hope we can agree that the current system needs reform. reform that can deliver better outcomes for shareholders and directors.
Perfect. Well done. Thank you, John. Simon, from an asset owner perspective, or a funds management perspective, would you like to add some comments?
Yes, thank you very much. I think John's right. This is a shareholder problem or issue. We need directors, and it is very much in our interest to make sure that a platform is created in which directors can easily fulfill their responsibilities and operate in an effective manner. But at the heart of exercising your responsibilities comes that concept of accountability, which Sarah alluded to earlier. And without accountability, the system is broken. So in order to create a framework in which shareholders can feel safe that poor directors are discouraged from taking on responsibilities of stewardship, that sense of accountability must be present in every facet of their work. And it's our belief that the honest and reasonable director defence doesn't go sufficiently far to make sure that that level of accountability is present. Honest people are important people. They're the type of people we like to befriend and entrust our children with. But I think when it comes to being the steward of a company and on the board of directors, it requires something above and beyond that. You want to make sure that people who become directors are not only honest, but they also have strategic vision, that they are capable. I think John used the best and brightest. It's our concern that by having safe harbours like the honest and reasonable test, you attract people, anyone, to the table to be a director, any Tom, Dick and Harry, because they'll get $250,000 with very little personal liability every year. They may honestly make decisions which may prove to be catastrophic from the perspective of a company's future, and which they themselves may actually be seen through the eyes of another reasonable person to be negligent. And so this safe harbour doesn't capture fully these negligent or misplaced strategic decisions which directors can make. If we go back to first principles, though, the system in many respects doesn't appear to be broken in the way that we've already discussed. I see few examples of director liability manifesting themselves in case law. In fact, if the system is broken, it's broken in a different way. All of the liability issues that come to the fore at the moment are through class actions that are brought about against the company and not the director. They always result in these out-of-court settlements, and it's shareholders who end up forking or paying the bill. It's not the director themselves. And so if the system is broken, and I agree in some respects it is, I would say that's probably where it is, rather than there not being enough personal, or rather than there being too much personal liability. John, you mentioned that directors wanted to provide more forward-looking statements, and it seems to be a big tenet of limiting liability from here. And one of those reasons is to help with investors in making decisions in investing. Well, it's not the responsibility of the board to help investors and shareholders make investment decisions. It's the responsibility of the board to do a range of other things which you're completely familiar with. This forward-looking statement mentality we've gotten ourselves into is not a requirement in law. It's a guideline by ASIC, and perhaps that's what needs to change. It's one of those things that promotes short-termism. It's very difficult to foresee the future. It is quite random. And so rather step away from having to hold investors' hands through the process and let the process and the future unfold in the way which it does. And it's oftentimes got nothing to do with the board. And so offering this guidance and exposing yourself to liability is something that needn't happen. And it's not the reason you need to change the personal liability laws which currently prevail. So there's a couple of other points I wanted to make, and I will run well ahead of time, but we're inundated with people who come into our office requesting our support in them becoming directors of various companies. Inundated. And that doesn't strike me as the sign of a system that doesn't work. There's plenty of people who want to be directors of companies, and a lot of the surveys we do are from incumbent directors who are already part of the system, the directors club, as you may like to call it. The other thing is this perception that changing personal liability will change the risks that directors are willing to assume in progressing the company or taking the company forward, I think is flawed. Risk takers are... laws don't really change whether you are or aren't a risk taker. Some people are naturally risk-taking, other people are naturally risk-averse. And just by changing some personal liability clause in a law somewhere, it is not going to help the leopard change their spots. And even if it did, do you really want it to happen? Do you want directors to assume far more risk than is already the case? Do you want us to move down the spectrum or towards the point of investment banking where there's a huge asymmetric payoff in the risk profiles they take? Great reward on the one hand, and no personal liability on the other end of the spectrum. It's not equitable, it's not symmetrical, and it's not accountable, and it's not something which shareholders will support. Thank you.
Thank you, Simon. And as the corporate lawyer, I'd say vote one, risk averse. So, Ian, your comments.
Thank you, Sarah. I'll make 3 points in my brief presentation. First, directors do have some legitimate concerns regarding liability. Second, I don't believe that the AICD proposal is the best way to deal with these concerns. Third, I suggest a way to deal with the concerns. My first point is that directors do have a number of legitimate concerns. Let me provide an example. Several years ago, the Corporations and Markets Advisory Committee published a report titled Personal Liability for Corporate Fault. The committee identified what it perceived as a major problem: the increasing tendency of governments, particularly state governments, to impose criminal liability on directors and officers where the company had breached a statute. The liability was imposed on directors and officers without the need to show any fault on their part. It was automatic liability. There were defences, but these typically differed from statute to statute. Liability did not depend on the director or officer being at fault, being personally involved in the breach by the company, or even knowledge by the director or officer that the company had breached the statute. Liability was imposed because of the position held by the director or officer. The committee identified hundreds of statutes across the states that adopted this approach to director and officer liability. Now, the committee stated in its report that this practice was objectionable as a matter of principle and discriminatory in the way that it treated directors and officers compared to how others are treated by the law. For example, reversing the onus of proof, which is what these statutes have done typically, by requiring a director or officer to prove a defence, is inherently unfair and unreasonable and strikes at the presumption of innocence. In addition, imposing personal liability without fault can be a significant disincentive for some people taking up directorships, and to my way of thinking, doesn't achieve the right balance that Sarah identified between wanting directors to be accountable but at the same time encouraging entrepreneurism. The committee was bold enough in its report to suggest that the reason state governments enacted this type of automatic liability was political expediency, that it looked good for governments to tackle an issue perhaps in occupational health and safety or another area by imposing this sort of automatic liability. Now, what we've seen is state governments recently start to unwind this type of liability. I suggest that most of the concern about whether the law imposes too many obligations on directors and whether there are too many liabilities on directors is not really a debate about the Corporations Act or indeed the ASIC Act, which is what the AICD proposal addresses. The Corporations Act has key duties that apply to all directors, no matter what the size of the company. A duty to act in the best interest of the company, a duty to act with reasonable care, and a duty to avoid conflicts, for example. But it's the myriad of other legislation, much of it at the Commonwealth level, certainly much of it at the state government level, that imposes obligations and liabilities on directors in so many situations. This leads to my second point, which is that I don't believe the AICD proposal is the best way to deal with genuine concerns that directors have. We should note that there's a principle developed by the courts over many, many years, which is that they will not review good faith business decisions by company directors where those decisions have been made following a proper process. Now, the AICD is of the view that this court-developed principle, as well as the statutory business judgment rule applying to the duty of care in the Corporations Act, which John referred to, provides insufficient protection to directors. But when we look at the AICD proposal, it should be noted that the defence only applies to the Corporations Act and ASIC Act and equivalent grounds of liability at the common law, but it doesn't apply to other Commonwealth legislation or to any state or territory legislation. So most of the issues that concern directors, it seems to me, are not affected by the AICD proposal. But there's another very important point to be made here if we look closely at what the AICD is proposing. And John mentioned the requirements for this defence to apply. The director must act honestly, act for a proper purpose, and act with a degree of care and diligence that the director rationally believes to be reasonable in all the circumstances. I suggest that what's proposed by the AICD represents a profound change to the current law. Let me give you just two examples. First, we have a duty that requires directors not to have a conflict of interest. The existing business judgment rule in the Corporations Act specifically states it will not apply where a director has a conflict of interest. The US business judgment rule specifically says it does not apply where a director has a conflict of interest. This requirement is not stated to be part of the AICD proposal. Now, it's significant that it's missing because sometimes we hear that ASIC is too aggressive in its pursuit of directors for the breach of the duty of care. But we've done some research looking at the last 22 years of cases brought by ASIC for breach of the duty of care from 1993 to 2015. There's 30 of them, so not an earth-shattering number. But in fact, the majority of those cases also involve ASIC arguing a breach of the duty to avoid conflicts. In other words, that the director lacked loyalty. So much of ASIC's litigation that is about the duty of care is largely about conflicts of interest. It's a real puzzle why the AICD defence doesn't very clearly state that it doesn't apply where a director has a conflict of interest. And if we look at the requirement that director rationally believes that they're taking the degree of care, that's very different again to what the current law is on the duty of care. Now, in the AICD proposals paper, it actually tells us, gives us some insight into what the AICD means by a director rationally believing that they've acted with the degree of care and diligence that the defence requires. And let me just quote from it. It says, the definition of rational in other contexts includes, and this is a quote, not foolish, absurd or extreme, not patently frivolous, not capricious, a decision that is so blatantly imprudent that it's inexplicable. Okay, so we pause there because we have to realise that this is very different from what Parliament has told us in the Corporations Act and what courts have told us over many years is the duty of care expected of company directors and officers. It's not a standard that says that directors can take advantage of the defence, provided they're not foolish or not absurd in their decision making, or don't act capriciously, or make a decision blatantly imprudent. In other words, I really believe the AICD proposal goes much too far. And let me then conclude with my third point. How do we deal with legitimate director concerns? In my view, rather than introduce a very broad proposal that's nowhere evident across the world, I should add. No country has introduced anything like what the AICD proposes to introduce in Australia. So rather than introduce a broad proposal, when it's applied by the court successfully to a defendant, would represent a profoundly different standard to what is currently expected of company directors. Rather than do that, we need to carefully identify what are areas of genuine concern and work to ensure the law reflects the right standard, so we can learn from the experience with the state legislation that imposed automatic liability on company directors without fault. following the report of the Corporations and Markets Advisory Committee that identified it as a major concern for directors, and following, I might add, effective lobbying by AICD and other peak organisations, the state governments have now been amending their laws. We might suggest some of them have been a bit slow, but there's really been very strong progress. John mentioned directors' liability for insolvent trading. I think there's a genuine issue here for company directors as to whether additional protection is needed for directors from the threat of personal liability for insolvent trading while making a good faith attempt at a company reorganisation or workout outside of external administration. There can be powerful advantages to workouts, and we do know that the interests of creditors may be better served by a workout or reorganisation than putting the company into administration. We also know that a director concerned about insolvent trading liability will not consider the option of a workout if the director is unable to form a positive expectation the company is solvent. And in addition, determining when a company is insolvent is not always easy. And making sure that directors are protected can assist them in circumstances by easing pressure to put the company into voluntary administration rather than having a workout. So in summary, I suggest the best way forward is to identify those areas where directors have legitimate and important concerns, and then the case is presented to government with the support of AICD, and we've already seen effective lobbying by AICD in relation to the state liability legislation that I've indicated, but also with the support of other groups, including investor groups, to provide appropriate protection for directors to ensure that the balance is right between director accountability and protecting directors' decisions made in good faith and that are also well informed. Thanks very much.
Now, the divergence of opinion, I think, on a panel really exemplifies how complex this issue is, and also how important it is in terms of corporate governance in Australia. I would like to open the floor to questions, and the roving mics will be going around. To kick that off, though, I have a couple of questions myself for the panel. And John, I'll start with you, just because you're sitting next to me. Now, please tell me if I'm misconstruing the AICD's proposal, but there seem to be two main issues here. First of all, that the current business judgment rule promotes a risk-averse culture on boards, and so that, I think the word you used was hamstrung. Directors feel hamstrung in taking sensible commercial risks. And the second issue is that the current regime disincentivises the best and the brightest from applying for board roles. So in relation to those 2 points, my questions are these. First of all, can you give us some examples of conduct that you think has been unduly constrained by the current form of the business judgment rule, but that would have been permitted under the AICD's proposal for reform? And secondly, in relation to the disincentive for the best and the brightest to join boards, I can understand how that is very true for not-for-profit boards, where it's all risk and no reward, but certainly from an asset owner perspective, how that really applies in an ASX board context where you are quite handsomely remunerated to compensate you for the risk that you're taking on.
So I'm going to have to review your role as a lecturer at the AICD. If you think that taking on the role as a not-for-profit director is all risk and no reward, obviously you're not on the board of a not-for-profit.
I am.
Well, I'm disappointed because I think there's enormous reward.
Oh, well, just not financial.
Which is why you join a not-for-profit board. Yeah. Of course, the greatest lie known to man and woman is, please join my not-for-profit board, it won't take up much of your time. Haven't we all been caught in that that cul-de-sac from time to time? Look, on the second issue, which related to, remind me now.
Not-for-profits.
Not-for-profits.
Versus ASX.
Look, it's an absurdity, firstly, to suggest that every ASX director earns $250,000 a year. And I think if that's the inference in that point, I think it does belie the fact that for many people it is an enormous amount of work. And it's if you were charged by the hour, you'd be earning more than your $40,000, $50,000, $60,000 a year that I think is more broadly, particularly in the sub 100 ASX, more likely to be your remuneration. The reality is, as I do, sit on both for-profit and not-for-profit boards, I don't particularly walk through the door with a different attitude to my corporate governance responsibilities and to my director's duties. Now, I speak for myself when I say that, but I can tell you once again personally that at Lifeline we adopt the ASX governance principles, and a large and growing amount of our members and clients at the AICD are in fact the not-for-profit sector who strive for excellence in governance. If not for any other reason that when they go appropriately looking for corporate support, they want to identify that they are properly governed and it's not just a mum and dad show. So I don't think directors take different approaches depending on which hat they're wearing and which boardroom they walk into. One of the challenges in our argument, without any shadow of a doubt, relates to the first issue, which is how do we measure, the second issue once again, which is how do we measure decisions that have not been made as a consequence of the current regulatory environment. And it is hard. It is hard to know that. Probably the easiest area to measure, and once again, we're trying to do some work on this because it is hard to measure, and a lot of this happens in companies with very low profiles, is, and Ian, you referred to this as well, is the decision to go into administration weeks or days before when you have to because you are so worried about your personal liability that you call in the administrators. That is, without a doubt, a live and real issue that is a concern for anyone on a board, and it's appropriate that they are concerned about trading whilst solvent, or indeed trading whilst insolvent. But at the same time, it does discourage good business decisions based on people's personal liability. And we seem to accept that quite openly, although in accepting that we readily acknowledge that directors are putting their own interests ahead of their shareholders' interests. However, it's a very simple decision. Who's willing to put their house on the line for that decision at the risk of over the risk of a couple of days?
I think one of the reasons that's often raised for the risk aversion and the over focus on compliance on boards at the moment in Australia, allegedly, are the decisions of the courts in the Centro case. And in the James Hardy case, where non-executive directors were held liable in breach of their duty of due care and diligence. And one of the charges that has been raised against the current business judgment rule is that it's only been successfully applied in one case in the last 13 years. So it's 15 years we are now. So that in that respect, it hasn't been of practical application and practical use for directors. Ian, can I ask you, now I know it's difficult to reconsider a legal case in hindsight, but if you're looking at those cases that have prompted this concern that compliance is overly focused on, if you're looking at Centro and you're looking at James Hardy, would they have been decided any differently under the honest and reasonable director test that the AICD is proposing?
So I think there's an argument that they would be decided differently. Now, whether that's a good thing is a major issue. We might quickly recollect that in each of those cases, in James Hardy, the directors were found to have contravened their duty of care by approving a draft public announcement that was seriously misleading. It said that the Medical and Compensation Foundation set up for those who had suffered asbestos-related diseases as a result of coming into contact with James Hardy products, or would suffer asbestos-related diseases, liabilities. They would be, the foundation was fully funded, and the court found that in fact the $293 million was grossly inadequate. The outstanding liabilities at that time were in excess of $1 billion, and the court found that the directors should have known, based on the information that they had, that draft announcement was in fact misleading. In the Centro case, there were several $1 billion of liabilities, short-term liabilities, that weren't appropriately classified in the financial statements of the Centro group. I'm simplifying a little bit here for the purposes of just identifying why the decision might be different. So when we apply the AICD test, or defence if you like, that the directors acted honestly, there'd be no doubt that those directors acted honestly. Did they act for a proper purpose? Presumably. One might have some questions about it. So it really boils down to the test that the AIC defence would have about the duty of care, which is this test, of course, and I mentioned in my presentation, the degree of care and diligence that the director rationally believes to be reasonable in all the circumstances. And when we turn to, as I said, what the AICD paper accompanying the proposal says, basically, that it's the degree, rational means not foolish, absurd or extreme, not patently frivolous, a decision that's not so blatantly imprudent that it's inexplicable. I reckon a court faced with those words might reach a different decision. And I think with the benefit of hindsight, particularly on some of those cases, that's not necessarily a desirable outcome.
Now, I do have some questions from the floor already over there.
Hi, Eva Shealing from AIST. Just want to make a comment on what Ian just said then. When you read out those words, it's a pretty low bar, can I say? And anyone wanting to be a director of a company really should be prepared to take on whatever responsibility that comes with that. Directors don't make decisions in isolation. To borrow the words from David Gonski before lunch, they make them as a team. My question is this. If we were to change the law and have the AICD test come in, would that mean that there would be an opportunity, I guess, for people to become lazy as directors and hide in the group and not perhaps have as much rigour around their decision-making processes? And also, what about the value of diversity in the group to bring more rigour to those decision-making processes that perhaps we don't need to change the test for liability?
John?
So the answer to the first question is no. The second question, what sort of diversity are you referring to? Broad diversity. Such as independence on boards, like super boards? Thanks. No, just interested to see where that question came from. So what I would say is that if you look at the skills matrix, which is now being applied as an if not, why not requirement under the ASX corporate governance guidelines, that does, without a doubt, require greater diversity. The greatest problem I have with the attitude that's taken by people on boards is, and those of you who are on boards, and this does happen on for-profit and not-for-profit boards, is when you come to approving the accounts, everybody looks to the accountant on the board, hoping they'll bless the accounts and then we can all move on to the next point. Now, that doesn't happen often, but where it does happen, that's a clear abrogation of responsibility. So what's the challenge there? You might be the IT guy on a board. You still have to be a director who agrees with what the accounts say. You still have to be able to sign off on the accounts. So the flip side of this coin is what we're now seeing in some boards is, and Fairfax has done this recently, is appoint a guy who wears a t-shirt and jeans to be on their board as their IT guy. Now, without any reference to him, does that allow every other director to abrogate their responsibilities in understanding what social media is and the future of that company? So boards have to act as a team. David Gonsi is exactly right. And the skills matrix does need to apply. But everybody must and always should be responsible for a decision that a board makes.
Now, your answer there to the first half of the question, John, was no. full stop. Simon, perhaps you could give us some observations about whether you think that the change from a subjective test of rationality to from an objective test of reasonableness would result in less rigour being able to be applied to decisions directors are making?
Okay, it's hard to know, but certainly from where we sit, looking at how that might manifest itself, it seems that would result in less rigour, and it's one of the reasons why we would be staunchly opposed to it. But not actually being there and knowing what it would be like and hopefully never finding out, it's very hard to definitively answer that question.
Well, but turning that question around a little bit and being constructive about it, what do you think, rather than a legal reform, what do you think is needed to apply more rigour to the decisions that directors are making and for them to be accountable to asset owners? Do you think that the system actually needs to be strengthened?
I don't think the system has these wholesale aspects which are broken and therefore need fixing. I think for the most part it works. I think when it comes to rigour, you want a board which, whilst it functions, this collegiate thing where everyone slaps everyone on the back and gives everyone hugs at the end of board meetings cannot be a good thing. You want the rigour to come in with very different frames of reference and diversity, and but at the end of the day, you do need to come to a decision as a board and implement the strategic direction. And I think there's a lot of things that are currently in place to make sure those happen, provided shareholders and boards make sure it does happen. I mean, it's not something which is restricted in law. So I'm not so sure that too much reform is needed. When I spoke earlier, I think part of the system that is broken, and I would definitely agree with John, I mean, it's in shareholders' interest to make sure that the bankruptcy, and this perhaps something more akin to a Chapter 11, Chapter 7 bankruptcy is brought into being in Australia. I think that is critical and a great development were it to happen. But other than that, I think that class action and this culture of class actions and settlements to appease these would-be litigants, that's the aspect that's broken, and perhaps we could have some reform around that. But I think that reform is make the directors more personally liable so that the class action litigants go after the director, not after the company.
Okay, I better put a barrier between John and Simon there. There was a question down there. And then last one over at that table there.
Hi, thanks for a great panel. Martin Lawrence from Ownership Matters. I have a question picking up on something that Ian said to John, and I know you're not a lawyer, John, so I'm kind of putting you on the spot. Is there a reason why the self-dealing aspect is not part of the AICD's proposed offence? Because if you think of where directors have actually gone to prison, where there has been real liability in recent times, though not in the case of the ABC directors, it's been in cases like HIH where there has been an element of self-dealing and prison terms.
I'm not sure I can answer that question, to be honest, at this stage.
I would say self-dealing is usually dealt with under the conflicts provisions. So on the basis of the generalisation of the defence, you'd assume that it would have been covered under that. And I had one last question on this table here. Get the microphone.
John Murray, CVAS. John, it's always a fine line as to where one strikes a balance between encouraging innovativeness and flexibility and on the one hand, and accountability and on the other hand. But I'm not quite sure I accept the thesis or the premise that on your initial premise, where you assert that there is a tendency for directors, in fear of their personal liability, to as it were, bring forward the move towards a VA than what would otherwise be necessary or be the case. Certainly from my experience in the building industry, I would have thought the very opposite is the case. Otherwise there'd be a heck of a lot more subcontractors still in business because builders, for example, had not taken the necessary step and had not traded whilst insolvent. So I just don't know where that sort of I don't quite accept that. But even if I assume that what you say to be the case, at the end of the day, I mean, if the balance between flexibility and accountability is such, then what's wrong with placing a greater emphasis on ensuring good corporate governance, if at the end of the day it engenders a greater corporate citizenship and a better society than one that, as it were, enables people to take risks excessively to the harm of others? Do you agree?
With what? Long question. What I would say to the first half is that I think it is, and I say this respectfully as the son and brother of a carpenter, that I don't think you can compare the Phoenix house builder to the broad behaviour of the business environment. So what I would then say is that where you do have boards that are serious about the practice of good governance, they will be taking very seriously, particularly at times of stress, times of capital raising, refinancing and the like, they will take very seriously their personal responsibilities with respect to solvency, and they should. So I think we agree on that. The risk you run in a practical sense, and Ian may wish to add to this more authoritatively, is, and it can literally only be a matter of days, I think that would be fair to say in some cases, Ian, where you call in the administrators because you don't want to run the risk of being personally liable on a solvency issue. You do that when there are still opportunities for reinvestment or for shareholder involvement or new capital to see a company through. And in doing so, you put out into administration a business that, in most cases, if you go into administration, the shareholders will take some form of a haircut. And secondly, the real risk you run is what could have been a great company that couldn't get through a difficult period and opted for insolvency rather than to battle through and hope for the best with good strategic reasoning. So not hope for the best, but see their way through. They pulled the plug on a company that, if it got through that period, could go on to be a great wealth creator for Australia.
Now, obviously, based on the panel's views this afternoon, this is just the beginning of the conversation rather than the end of the conversation. And I'd like to thank our three panellists today, John Brogden, Simon Mulweny and Ian Ramsey, for their valuable contributions to this discussion.